The law draws borders, allocates rivers, and governs the movements of goods. But the grape answers only to sun, soil, and rain. Across Africa, these two forces, statute and nature, are colliding. When water becomes scarce, who decides who gets to grow, who gets to survive, and who gets left empty handed? I'm Untatile, and this is the Gavel and the Grape, where we break down the law behind the label. This is the podcast where we treat the statute book as seriously as the tasting note. In this series, we aren't just talking about terroir or tenants, we're exploring the policies, the politics, and the legal frameworks that determine the future of African agriculture. Before we begin, let me tell you how this show works. Each episode of The Gavel and the Grape follows the same structure. We begin with a case file, a deep dive into a legal framework shaping African agriculture. We examine the legislation, the policy architecture, and the real implications on the ground. Then we move to a comparative poll, where we step outside one jurisdiction and examine how another African country approaches the same issue. After that, we bring it together in synthesis. What does this mean? Where are the risks? Where are the opportunities? And finally, we close out with probably my favorite section, our verdict vintage. We pour a wine that captures the spirit of the legal question we've unpacked. Because law, like wine, is shaped by structure, and structure tells a story. Now, let's open our first case file. On today's docket, water law and the African vine. First, we open the case file on South Africa's National Water Act, the shift from colonial riparian rights to the modern public trust model, and why administrative ghosts still haunt vineyards in the Cederberg. Then, for our comparative poll, we travel to Ethiopia, where state-centered law offers a very different terrain for viticulture. And finally, in our verdict vintage, we pour wolf and woman, always present, often invisible, Chenin Blanc. A wine that captures the hidden structures beneath the swirl, not unlike the hidden structures of water law. So pour yourself a glass and let's decant the law behind the label. At the heart of today's episode lies this question. When water is scarce, how does the law decide the possibilities and the limits of water access for African vineyards? To answer that, we begin in the Western Cape, where vineyards have long been shaped not only by drought and heat, but by a deeply unequal legal past. Before democracy, water access was governed by riparian rights. If your land touched the river, the water was yours. If it didn't, you were excluded. Inequality was built into it by design. Everything shifted in 1998 with the enactment of the National Water Act 36 of 1998. Overnight, water became a national resource held in trust by the state for equitable and sustainable use. Water was no longer a private entitlement attached to land. It became a public good, allocated according to equity, redress, and ecological sustainability. But this legal revolution left ghosts. The most persistent is existing lawful use, often referred to as ELUs. ELUs were meant to be temporary, recognizing pre-1998 water use while new licenses were being processed. It was never meant to be a permanent right. It was a transitional entitlement. But it fossilized. Licensing backlogs remained severe, catchment management agencies rolled out unevenly, hydrological data is incomplete, administrative capacity is stretched. The result is legal limbo. Farmers operate within a system that was never designed to last this long. During the 2017 drought, the stakes became visceral. Vines stood in heat, cracked soil, while farmers waited for licenses to determine whether water could legally flow again. In those moments, a license is not just paperwork, it's survival, and it carries financial implications. In South Africa, water use entitlements cannot be sold separately from land. They are not freely tradable in isolation. That makes vineyard valuation complex. How do you price land when its most essential input is conditional? South Africa is not alone. Across the continent, water law is being reshaped under the twin pressures of climate change and agricultural ambition. Travel northeast to the Rift Valley in Ethiopia, where a small but notable wine industry is emerging, including estates near Ziwe, where volcanic soils promise excellent fruit. The legal terrain here is entirely different. While South Africa restructured an inherited system, Ethiopia constructed its framework with clarity from the outset. Under Ethiopia's Water Resources Management Proclamation, all water resources are vested in the state and the people of Ethiopia. The hierarchy is explicit. Domestic use comes first. Drinking water, public services, household needs, agriculture, including vineyards, require a permit. Commercial irrigation depends on state authorization. Permits set allocation caps, impose fees, and prescribe conditions. On paper, the structure is orderly. In practice, implementation depends on regional capacity, enforcement, and hydrological reality. Vineyards draw from the same water systems that sustain communities and smallholder farmers. In dry years, competing claims converge, and once again, the law must decide who takes priority. It's a fragile balance, one that shifts with each new season. So let's return to the central question. When water is scarce, how does the law decide who gets access? The answer is layered. Legal frameworks grounded in the public trust doctrine can provide long-term stability essential for agricultural investment, but implementation determines reality. In South Africa, administrative inertia slows the transition from temporary entitlements to formal licenses. In Ethiopia, regulatory capacity shapes predictability. Across both systems, water rights are conditional, revocable, and embedded within fiduciary relationships between the state, its people, and the natural environment. It can feel uncomfortable, but it is central to building a more equitable and climate resilient agricultural future. And now our verdict vintage. Wolf and woman, always present, often invisible Chenin Blanc, from the Olifants River region, where water scarcity is not theoretical, it is a daily reality. These wines are dry farmed, drawing moisture from deep within the soil. Tasting it, the wine is taut yet textured, with grippy acidity and a linear mineral spine, citrus peel, white pear, and a faint saline edge, as though the soil itself is whispering through the glass. Each flavor feels earned, each drop a testament to survival. It resonates because the most powerful forces in law and nature are often unseen. Deep roots, foundational statutes, institutions that quietly hold everything together. Water may be invisible at the surface, but without its careful governance, nothing thrives. Thank you for joining me on the Gavel and the Grape. If today's episode added value, subscribe and follow the show. You can find the Gavel and the Grape on YouTube, Apple Podcasts, Spotify, and wherever you get your podcasts. Next week, tariffs, trade wars, and the African wine exporter, a journey into how trade law shapes what makes it from vineyard to glass. Check the show notes for legislation sources and today's verdict vintage. Until next time, always decant the law behind the label.